Well, I suppose the primary way in which the European Court of Justice can become involved in a dispute before the Irish courts is by means of the reference procedure. Where an issue of European law arises before the Irish courts, and the Irish courts feel that they require the assistance of the European Court of Justice in order to decide the particular issue, then it is open to the Irish courts to refer that particular issue to the European Court of Justice, to get a ruling from the European Court of Justice on the particular issue, and then to apply that decision to the facts of the case before them. It's not a procedure that's invoked that often, but it is important that you can get a definitive ruling from the European Court of Justice, particularly in relation to matters where there have not previously been a ruling of the court. Are the courts suitable for solving procurement disputes? I think probably the reality is that the courts are the best. It's not to say that they are the perfect means of solving procurement disputes, but they are the best means available. Because of the complexity of the procurement directives and of national implementing legislation, it does require a certain degree of legal expertise to interpret and apply the directives and some of the underpinning concepts such as equality, transparency, non-discrimination, etc. So I think that it would be very difficult for non-lawyers to interpret and apply the directives, and so that therefore the courts are the natural repository for disputes in relation to the procurement directives. And so far as there are sometimes suggestions that procurement disputes should be taken out of the court system and entrusted in the hands of some type of expert arbitrator in the area or whatever, I think you'd have difficulty in setting up a parallel process that would have the expertise that the courts can bring to bear to a dispute, because it's important to remember that when one deals with procurement disputes, they don't take place in a vacuum and they don't take place in isolation from other legal principles. So that in a given procurement dispute, issues can arise in relation to the interpretation of legislation, directives. That's a sort of a specialist function that the courts are well equipped to handle. You can have other considerations like you might have time issues. One of the essential characteristics of procurement legislation or procurement litigation in this country are the very tight time limits that apply. Issues can arise as to whether those have been complied with or not. That is something that the courts are well used to and well equipped to deal with. You can also have ancillary reliefs required in procurement proceedings. There can be a requirement for discovery. There can be a requirement for the service of interrogatories. There can be a host of normal court procedures that apply in litigation across the board that are suitable and necessary in procurement litigation. So I think it would be very difficult to take procurement litigation out of the courts. And while there are obviously ways in which you can improve the way that the courts deal with procurement litigation, I wouldn't agree with the idea of taking procurement disputes away from the courts. And I mean, one recent development that should be noted in relation to procurement disputes as well is that you now have the option of transferring procurement disputes to the commercial list of the High Court, which provides an extremely speedy and efficient way of resolving them. And when you deal with procurement disputes, particularly where there's a challenge to a tender award, one of the primary objectives in dealing with such a dispute is to resolve it quickly and also to achieve consistency in decision making. And I think those objectives are achievable within the court system. Judicial review is a process whereby the courts control the decision-making processes of lower courts and of tribunals. And the basic aim of judicial review is to ensure that correct procedures are followed, on the premise that if the proper procedures are followed, the correct result will eventuate. But judicial review is not about the actual merits of a decision, and it's a point that is sometimes underappreciated in relation to procurement challenges, is that the courts are not in the business of actually deciding who had the best tender or who on the merits of the bid competition should have won the tender. It is the courts are more concerned to ensure that the proper procedures were applied, that, as I say, principles like equality, transparency, non-discrimination, and that were applied, that fair procedures were adopted. And as I say, the theory is that if all of these are implemented, then the correct decision will ultimately come about. There are a number of concepts that one comes across in relation to procurement disputes and in the application of the procurement directives. One is the idea of equality of tenderers, and basically that means that all tenderers should be treated equally. So they should have the same information made available to them. They should be treated equally in the sense that if there are any shortcomings in their bids, in their tenders, the failure to include a document or whatever, that shouldn't be waived in the case of one tenderer, but yet prove fatal in the case of another tenderer. So it's a general principle that the various tenderers be treated equally. Yes, one of the really underappreciated aspects of procurement law is that it is not confined to the application of the various procurement directives and the national implementing legislation. There is a line of case law from the European Court of Justice whereby it is held that certain of the fundamental procurement principles like equality, non-discrimination, transparency apply even where the directives are not applicable, because they ultimately derive from treaties of the European, or from articles of the European Treaty. So that it's an important point to bear in mind that even if the directives are not applicable, these various principles may very well apply and must be factored into decision making in terms of how you decide to have a tender competition, how you run a tender competition, and how you actually award tenders.